Welcome, everyone. Welcome, and thank you for being here in a prompt way so that we can get started. I'm Jacob Levy. I'm the coordinator of the Research Group on Constitutional Studies and the director of the Jan P. Lynn Center for the Study of Freedom and Global Orders in the Ancient and Modern Worlds, of which RGCS is a part. The Research Group on Constitutional Studies is now more than 8 years old, and it brings together faculty and students from political science, philosophy, and law interested in questions about the values, institutions, and principles that help to animate the constitutional orders that govern societies. The RGCS lecture series, aimed in particular at the study of the values, institutions, and principles of constitutional orders of free societies, has sought for most of the time that RGCS has existed to bring leading scholars either in political theory or of interest to political theory from a variety of interdisciplinary settings across philosophy, the social sciences, history, and law, to McGill to be able to communicate things that they've found in their research in a way that is accessible to and of interest to the student population, aiming to overcome the traditional barrier between faculty who travel giving research papers to other faculty and the interest that there is in providing talks that are accessible to students that too often take for granted that serious research faculty are inappropriate. What we found over and over again is the serious research faculty who are also fine teachers are able to come and give talks that bridge that gap to an audience of students who are interested and engaged enough to show up and want to follow. As of a few years ago, RGCS became a part of the Lynn Center, and the Lynn Center spans a much broader range of disciplines across the university, providing a home for humanistic social inquiry, the study both historical and normative, about how to think about social orders around the world and across different regions of different eras of history. Within RGCS, in the lecture series, this year we have two of the very smartest rising stars in the discipline of political theory. After today's lecture, the next will be given on March 14th by Teresa Bejan of Oxford University. Following that, there are a couple of more Lynn Center events that will be of interest to political theory and political philosophy audiences. On March 28th, the Lynn Center's annual lecture will be given by Elizabeth Anderson, professor of philosophy at the University of Michigan and one of the most prominent political philosophers in the world. And on April 5th, there will be a jointly co-sponsored by several parts of the Lynn Center lecture by Samuel Moyn, who is a legal and historical scholar at Yale who studies the evolution and the impact of, among other things, ideas of human rights and the ideological purposes that those ideas have served. I encourage you to follow RGCS on Facebook or look at the Lynn Center's schedule of events at mcgill.ca/Lynn Center in order to stay up to date. For our lecture today, and the beginning of this year's RGCS public programming, I am delighted to welcome Turkuler Isiksel, who is the James P. Shenton Associate Professor of the Core Curriculum, a member of the Committee for Global Thought, and of the Department of Political Science at Columbia University, and this year is a Fellow in Residence at the Edmund J. Safra Center for Ethics at Harvard University. Professor Isiksel holds a PhD in political science from Yale University, and she's the author of Europe's Functional Constitution, A Theory of Constitutionalism Beyond the State, published by Oxford under its Oxford Constitutional Theory series. That book evaluates the extent to which constitutionalism as a normative and empirical concept can be adapted to supranational institutions. Isiksel addresses this question in light of the EU's legal order, arguing that the economically driven processes of European immigration has brought into being a qualitatively different form of constitutional practice that cannot be understood in light of the conventional, rights-based, and sovereignty-based models of constitutionalism. And those of you who know that one of the other research groups under the Lynn Center is the research group on global justice will recognize in that description quite how much Professor Isiksel's research crosses the boundary between the constitutionalist emphasis of RGCS and the global interest of the group on global justice. And accordingly, she will be giving a research workshop tomorrow in the Global Justice series. Her other research interests include the evolution of ideas about commerce and international politics in 18th century political thought, as well as theories of sovereignty, delegated governance, citizenship, cosmopolitanism, and Turkey-EU relations, as well as the problems of corporate personhood about which she will be speaking today. Her research has appeared in the Journal of Politics, Human Rights Quarterly, the European Journal of International Law, Global Constitutionalism, and Constellations. She has held a Jean Monnet postdoctoral fellowship at the Global Governance Program at the European University Institute in Florence, a fellowship in the Law and Public Affairs program at Princeton, an Émile Noël Fellowship at the Jean Monnet Center for International and Regional Economic Law and Justice at NYU, and a visiting research fellowship at the Justitia Amplificata Center for Advanced Studies at Goethe Universität in Frankfurt am Main, an institute with which the research group on global justice has ongoing important connections. After her lecture, we will take questions for a while, and then there will be a moment at which we'll give away a copy of Europe's Functional Constitution to a student in the audience. Then following all of that, we will adjourn to a reception immediately next door. Please join me in welcoming Turkuler Isiksel.
D'abord, je voudrais remercier le Centre Yampéline et professeur Jacob Lévy de m'avoir invité. C'est un grand honneur, un grand privilège. Et je remercie aussi Madame Nina Arendt pour avoir organisé cette visite. Pardonnez-moi pour continuer cette conférence en anglais. J'habite chez les anglophones depuis 15 ans, 20 ans. Et j'ai oublié la plupart de mon français, alors il faut respecter la langue. So I switched to English. The title of my lecture is What Rights Do Corporations Have and Why? When I tell people I'm interested in this question, that I'm doing research on this question, I get a couple of standard responses. First, outrage that business firms have hijacked the rights protections that are meant to protect flesh and blood human beings. The perception that firms opportunistically use these protections to avoid regulation and to maximize their profits. Or worse, they use these protections to translate their market power into political power and to dominate others whose interests conflict with their own. Or we're used to thinking about corporations as violators of human rights. These images are from protests against Royal Dutch Shell, which began drilling for oil in the Niger River Delta in Nigeria, causing great environmental devastation in the lands of the Ogoni people, who staged decades of protests against them. And Shell has been accused of colluding with the Nigerian regime in the repression of these protests, and in fact, in the summary trial and execution of some of the protest leaders. Or you might think of Unocal, the U.S. fossil fuel company, enlisting the Burmese government's help to build a gas pipeline through Burma in the 1990s, and indirectly colluding in that government's practices of forced labor, torture, executions, and disappearances, all in connection with the pipeline project. And no doubt that there are other examples that put corporations firmly on the side of violators of human rights rather than bearers of them. Now, these are all important worries, and they continue to receive their fair share of attention. But I think they focus on one corner of what I want to convince you is a far broader puzzle. Now, colloquially, we use the word corporation to talk about business firms. But if we're thinking analytically, that category includes a far wider array of entities than just businesses. For starters, not all businesses are corporations. Some firms, for example, are partnerships. This means that the assets are co-owned by the partners and not by a separate entity, i.e. the firm. And just as not all businesses are corporations, not all corporations are businesses. It's that latter part that's more important for me. Many other entities share the corporate form that are not aimed primarily at generating profits. So today, corporations come in an immense variety, but I want to highlight at the outset 3 defining features. The first, a legal identity that's distinct from the individuals who act through the corporate entity, which typically entails rights to own property, bring suits, the capacity to be sued, and so on. The second is a formalized managerial structure. And the third is the prerogative to govern its internal affairs by issuing rules. Now, you'll notice that this is a fairly legalistic definition. It describes more or less the general legal attributes of corporate entities in many Western jurisdictions today. I don't mean to suggest that the corporation should be understood in purely legal terms or that it's nothing more than this sort of legal construct. That's something I'll talk about more in a minute. But for now, let's consider what it might mean to exclude these sorts of entities from the scope of protection of rights norms. Last year, the Hungarian government passed a law that undercut the legal basis of the Central European University, a research institution that has operated in Budapest for nearly 3 decades and produced 15,000 alumni. The government, through a kind of narrowly tailored law, de facto revoked the license of this institution to operate as an institute for social science research in Hungary. It was widely interpreted as an attack on academic freedom and as part and parcel of the Fidesz government's efforts to undermine civil society, and perhaps also a function of something of a personal vendetta that the Fidesz leader seems to have against the university's founder, George Soros. That ought to sound familiar. Or consider the fate of the Halki Seminary outside of Istanbul. It has for over 100 years. It was founded in the mid-19th century. It trained the very top echelons of the Eastern Orthodox Church. In fact, it was first established in that location as a seminary in the 9th century of the Common Era, so it's over 1,000 years old. But in 1971, the Turkish government decided that it would require all institutions of higher education to follow a master curriculum and to become part of a state system of universities. These requirements, they can be construed as violations of academic freedom in their own right, but one of the things they did was to lead to the closure of this seminary, which only makes sense as an autonomous entity under the Eastern Orthodox Church. And then to add insult to injury, Turkish law enforcement demolished that beautiful 17th century chapel of a closed seminary. And then maybe some of you will have seen the recent feature film starring Meryl Streep and Tom Hanks depicting the famous Pentagon Papers case of 1971, in which the U.S. government tried to bar various newspapers, including the New York Times and the Washington Post, from publishing documents that showed the real extent of U.S. involvement in Vietnam. The U.S. Supreme Court found this, quote-unquote, prior restraint, that is to say, this attempt to prevent the publication of documents of public interest incompatible with the First Amendment of the U.S. Constitution. And finally, consider the case of an independent TV broadcaster in Italy that ran into the brick wall of the Berlusconi government during the 2000s. Now, media control, you might recall, was one of the central pillars of Berlusconi's strategy for retaining power. And during his time in office, Italy's broadcasting authority protected the Berlusconi-owned Mediaset Corporation's monopoly and repeatedly failed to allocate a broadcasting frequency to this rival network called Centro Europa 7. I'll spare you the elaborate story of, politically motivated bureaucratic foot-dragging there that landed Italy at the European Court of Human Rights and ultimately with a big fat fine. These cases all have something in common. Corporate entities suffering a breach of what looks like fundamental freedoms, like the freedom of expression, the freedom of religion, and assorted due process rights. It reminds us the cases all remind us that when we talk about corporate rights, we're actually talking about something far more varied, a far more varied set of cases than just firms. And they remind us that all of us rely on corporations to practice our professions, to gain an education, to practice our faiths, to form an informed opinion, to live out our life plans. So the disruption of corporate autonomy would affect all of us deeply, though in different ways. So the question of what rights corporations have and why is a question that we're all deeply invested in. And the answer to it doesn't neatly map on to the sort of left-right spectrum in politics, which is what makes it interesting from the point of view of a political theorist. And it's the kind of issue that people who are critical of corporate power have paid too little attention to. In my neck of sort of, quite progressive political theory, the question is greeted with a kind of collective, I can't even, So folks will tend to say, how about let's talk about the duties and responsibilities of corporations first. But whether you're interested in limiting corporate autonomy or protecting corporate autonomy, you're going to have to make an argument about their rights. So I suppose the first thing you might want to know is what kind of rights are we talking about? Do we mean legal rights, natural or moral rights, human rights, constitutional rights? If the question is what legal rights do corporations have and why, that question is easy enough to answer. Look at the law, look at the settled line of cases, connect the dots into a coherent argument, and you have yourself a doctrine. I know it's not that easy, of course, but I'm a political theorist, so I at least have to make it look like I'm benching more weight than my colleagues, the legal scholars. But we're not merely interested in rights that corporations enjoy by way of positive law. We want to know what rights they ought to have, what rights they deserve. Existing legal arrangements may or may not reflect these oughts. So maybe we're talking about natural or moral rights, rights that have their justification in first principles rather than any particular legal document or practice. Or maybe we're talking about constitutional or human rights, in which case we're doing a bit of legal positivism and a bit of moral argumentation. What makes human or constitutional rights distinctive is that they're fertile terrain for moral argument. Of course, they're also legal norms in the sense of being enshrined in authoritative legal documents, but we also understand them to have a meaning and significance beyond what's codified as law. And we often make reference to those principles when interpreting these typically quite vague and open-ended norms. We understand constitutional rights or human rights to involve morally well-founded claims that an agent has on the rest of society, and not merely claims that he, she, or it has as a matter of convention that could easily be otherwise. And of course, this is what all those examples that I gave were meant to do, right? They were tugging at your moral intuitions. So in the rest of my talk, I'm going to focus on human or constitutional rights. I'm aware that those are not the same thing, and in my previous research, I've talked about why it's important to distinguish between them. But today, I'm going to group them under quite a convenient rubric that I borrow from EU law and from the European Convention on Human Rights, namely fundamental rights. So my rephrased question looks a little bit like this. What fundamental rights protections, if any, do corporations deserve, and why? Fundamental rights norms bridge the moral and legal realms. They are morally well-founded claims regarding what kind of treatments agents are entitled to expect from public institutions. And in liberal constitutional systems, they're treated as high-priority legal norms, meaning that when they come into conflict with other considerations, particularly considerations of a collective sort, we expect them to at least have the presumption that they will prevail. Of course, they don't always. They have to be limited in accordance with other considerations, but at least they have this sort of high-priority status. So really the question is, are corporations the kind of subject that should enjoy fundamental rights protections? And I suspect that if that had been the actual title of my talk, I'd be speaking to a much smaller audience today. So what I mean by that is, what is it about corporations that might entitle them to the protection of fundamental rights norms? First, I want to examine 3 attempted shortcuts to answering this question, and I want to persuade you that they are, in fact, dead ends. So here are the shortcuts. Yes, corporations are the kind of subject that should enjoy fundamental rights protections because they are persons, ergo they have the rights of persons. The second shortcut is no, because human beings have unique attributes that make them worthy of protection that corporations lack. And the third one, that should have been a 3 and not a 1, yes, corporations are made up of people, ergo they have the rights of people. So the standard argument in favor of corporate rights is to say that corporations share some characteristic with human beings that makes them worth protecting. Exactly what that characteristic might be is a topic of long-standing debate. I'm going to focus on one of the more superficial answers to that question, or rather superficial attributes, because it's sort of easier to examine, one that for better or for worse has won the day in, for example, US constitutional jurisprudence, namely personhood, the shared attribute of personhood. And it's not exclusive to the US, by the way. Many jurisdictions recognize legal personhood, and many jurisdictions, when they see the word person in bills of rights, interpret them to encompass legal persons as well. It's my understanding, and I'm far from knowledgeable on this, but certain sections of the Canadian Charter of Basic Rights is also interpreted in this way, that when the word person appears, that covers legal persons as well as natural persons. So, like a human person, a corporation is a legal subject capable of suing and being sued, owning property, entering into contracts. And since the attribute of personhood is shared, so the argument goes, they're presumptively entitled to the same rights. Now, obviously, some of the rights that the law confers on human beings don't apply to corporate entities. It's sort of amusing to think of, the right to marry, the right against involuntary servitude, the right to bodily integrity being applied to corporate entities. But also vice versa. Corporations have rights that human beings don't have, such as the right to perpetual succession, entity shielding, limited liability, and so on. Now, here are some responses to that argument. There's a bumper sticker for you. This is from The Onion. This is one of my favorites. Now, these parodies respond to the very real fact that in the US, corporate litigants have successfully leveraged the status of personhood to acquire many constitutional rights. Now, most critics assume that there's a lot at stake in designating corporations as persons. It's sometimes argued that, that corporate personhood is a quote-unquote dangerous fiction, because it enshrines moral equivalence between human beings and corporations. It's a sleight of hand that vests the corporation's claims with a moral weight that they might otherwise lack, and raises the level of protection that they get under the law. These critics are particularly concerned about the power of one kind of corporation, namely the business corporation. So some in the US are lobbying for a People's Rights Amendment to the US Constitution that would look something like this. We, the people who ordain and establish this Constitution, intend the rights protected by this Constitution to be the rights of natural persons. The words people, person, or citizen as used in this Constitution do not include corporations, limited liability companies, or other corporate entities established by the laws of any state, the United States, or any foreign state. So in the view of these critics, the metaphor of corporate personhood has morphed into a kind of doctrinal golem. Its original function was to vest the corporation with legal standing, but it's actually become much more powerful. It does a lot more work than it was intended to do, and that an amendment like this is the only sure way to scale back the protection that corporations get by virtue of being considered persons. So it might come as a surprise that there's a second group of critics, so that's the first group of critics who say personhood status amplifies corporate power. There's a second group of critics that say that the legal status of personhood might actually help to make corporations more accountable. So one of the pioneering advocates of the idea of corporate social responsibility, Merrick Dodd, argued that personhood can give the state a handle on an entity that might otherwise elude its grasp, and allow the state to hold corporations responsible. And then there's yet a third set of commentators who argue that the category of personhood is basically so elastic that it has very little bearing for assessing the moral status of corporations or for delineating their rights. It confers on the bearer only those qualities that society, through its laws and institutions, decides to grant. Or worse, personhood functions as a kind of rubric that obfuscates the real reasons we have, the real reasons behind our arguments for or against corporate autonomy. Now, so it may be true that we could think of legal personhood as a purely legal concept, one that denotes standing and nothing more. In other words, we may be able to think of it as just a peg on which to hang different schedules of rights depending on the agent. But as a matter of everyday speech, we just can't wring out the moral connotations that trail the idea of personhood. And in fact, when litigants invoke the idea of personhood, they're in fact trying to piggyback on these moral considerations. So when civil societies go to court to get petition courts to recognize the personhood of chimpanzees or rivers, or when corporations go to court to have their personhood recognized, they do so in order to attach greater moral weight to their claims for recognition. Obviously, the merits of those claims are antecedent to personhood, but it's hoped that kind of shoehorning them into that category will help to vest them with greater urgency. Here's the problem I see with the personhood approach. That is to say, the idea of giving corporations whatever rights persons enjoy. Without some sort of further philosophical specification, it ultimately can't settle the underlying moral controversy about corporate rights. Because really what we want to know is whether a corporation is a person in the relevant sense. That is to say, in a way that justifies its rights claims. And the key to answering that question is not the intrinsic philosophical meaning of personhood. What's going to do the normative work is not whether or not something is a person, but what entitles that thing to moral consideration in the first place. We're going to have to stake out our reasons. It's on the basis of those reasons that we might decide to call them a person or withhold that designation. But what's doing the work is how we justify the agent's claim to moral consideration. In other words, when we invoke the corporation's status as a legal person as the reason that we should treat it, we should accord to it the same rights as a human being, we moot the very question that we're supposed to be debating, namely why and under what circumstances these entities deserve the protection of fundamental rights norms. And second, the personhood template glosses over important distinctions amongst corporate entities, which differ in terms of their social, moral, and policy significance. I don't think there's a prima facie reason for according all corporations the same set of rights. I don't think there's any reason to assume that a bank and a newspaper, for example, are entitled to equal treatment when it comes to speech in the way that two human beings might be. For now, I'm asserting, I'll put that bold claim right here and defend it in a minute. So if we abandon the criterion of personhood, what considerations are going to guide our assessment of the question that I started out with? The second, what I call the second shortcut, is to say that there is something about human beings that entitles them to special moral respect, and by implication, fundamental rights. And to say that corporations lack that special something. It might be sentience, it might be, uniqueness, self-awareness, possession of a will, mortality, ability to form a rational plan of life. Now, if I were to go down this route, my lecture would end up being more about human beings and what makes them special than it would be about corporations. And that's a pretty bloody philosophical battlefield, and it's not the one that I plan to die on today. But there's another sort of cleverer way of making this argument stick, which is to stake a claim about the kind of subject that a corporation is, and to argue that a corporation is nothing but a legal subject. So whatever it is you think justifies the high priority rights we accord to human beings, you know that a human being is more than a legal subject, and that it is these extra legal attributes that ground a human being's claim to fundamental rights. By contrast, this argument goes, we can't infer legal or moral prescriptions from the supposedly intrinsic or natural attributes of corporations in the same way that we infer moral and legal prescriptions from the intrinsic and natural attributes of human beings. That's because, so this argument goes, the corporation is a purely legal concept. It has no intrinsic or natural attributes, only those that the law gives it. To pretend that legal disputes can be decided in the light of some essential quality of the corporation is, in the words of American legal realist Felix Cohen, quote, to thingify the vivid fictions and metaphors of traditional jurisprudence, end of quote. Cohen once called the attempt to derive rights from the nature of corporations transcendental nonsense, very famous phrase. So from this perspective, the question of my lecture is kind of stupid. There's nothing perplexing about the question of corporate rights if you see the corporation itself as a creature of law. So here are a couple of illustrations of this point of view. This is Edward Cook writing in 1612, quote, endlessly quoted and misquoted passage. A corporation aggregate of many, that's in contrast to a corporation soul, a corporation aggregate of many is invisible, immortal, and resteth only in intendment and consideration of the law. Here is Chief Justice Marshall in the famous Dartmouth v. Woodward decision, of the US Supreme Court, incidentally, bears striking resemblances to the Central European University dispute. It was a case where the state of New Hampshire effectively tried to nationalize Dartmouth College, and the Supreme Court stepped in and said, not so fast. Where Chief Justice Marshall wrote, quote, "A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of its creation confers upon it." And finally, in David Seepley's pithy formulation, quote, "Having been constituted by government, the corporation can't properly assert constitutional rights against it." I think there are several problems with this way of proceeding. First, I think that the idea that the corporation is a mere creature of law is true only in the trivial sense in which any legal entity is a creature of law. I think most of us would be inclined to say that there is something to a corporate entity besides the legal framework that gives it recognition as a subject of law. Let me give sort of a silly example. Would we say that the Sinaloa cartel doesn't exist because the state refuses to recognize it as a subject of rights? My point is not, I underline this, also because we're being recorded, that the Sinaloa cartel should be lawfully chartered as a corporation or that it deserves to have fundamental rights. I do think there's a difference between a pharmaceutical company and a drug cartel most of the time. My point is this: insisting that corporations exist only in contemplation of the law is to take the law's comparatively narrow perspective as though it were the only one available to the social observer. It's to ignore social practice. The law undoubtedly shapes how corporations exist in the world, but describing corporations as mere creatures of law flattens the associational freedom that warrants their existence. It presupposes, I think, an unduly statist account of civil society. Even if we see the source of corporate autonomy in a grant of power by the sovereign, that grant is neither purely discretionary nor morally arbitrary. Rather, it's justified by, or perhaps sometimes even compelled by, the individual rights and interests for which the corporation serves as a vehicle. Which brings us to the third shortcut, which is that corporations are made up of persons, ergo they have their rights. Called this the Mitt Romney doctrine. He said that during this presidential campaign. Just been elected senator for Utah. So the central claim is that the corporation is nothing more than a convenient appellation for the people who constitute it. Its rights, therefore, should be approximated to those of the people that constitute it. A famous example of this is U.S. Supreme Court Justice Samuel Alito's majority opinion in the Hobby Lobby case, quote, "A corporation is simply a form of organization used by human beings to achieve desired ends. When rights, whether constitutional or statutory, are extended to corporations, the purpose is to protect the rights of these people." And conversely, it's argued that curtailing the rights of a corporation is tantamount to curtailing the liberties of the people who associate under its auspices. Here's somewhat of an older decision from the late 19th century. Justice Field writes, "It would be a most singular result if a constitutional provision intended for the protection of every person against partial and discriminating legislation by the states should cease to exert such protection the moment the person becomes a member of a corporation." Justice Field, one of these people who held a seat on the U.S. Supreme Court and on a circuit court at the same time. He was one of the architects, that was allowed at one time. He was one of the architects behind expanding the U.S. Constitution's 14th Amendment guarantees to corporations. And he was a great friend of the railroad corporations, which in turn were sort of frequent litigators in expanding corporate rights in the 19th century. litigants, rather. So I think this sort of aggregative approach has a central flaw, and I'm not the first to point it out by any means. It seems to ignore the defining feature of the corporate form, namely the veil that separates the corporation from the individuals that associate under its auspices. For example, a corporation retains its identity even as the composition of these individuals changes over time. If it were simply reducible to its individual members, it wouldn't stay the same legal entity once everyone who composes it, quote unquote, had left or died. But I think I want to focus on the important insight that I think aggregative theory brings to the table, which is that unlike the other two shortcuts, it actually gives us a compelling substantive reason to justify the corporation's claim to moral consideration and legal protection. It's not a formulaic thing. There's some meat there. It emphasizes the corporation's role as a vehicle for individuals to pursue their interests, to express their values, to further their life plans in association with one another. The corporation affords an important and sometimes essential medium for individuals to act in concert, particularly when their aims require a formal, lasting framework of cooperation and a secure commitment of resources. So by shifting us from the transactional to the institutional form of social cooperation, the corporate form broadens the horizons of cooperation. So here's how Jacob Levy puts it in his book, Rationalism, Pluralism, and Freedom. This is key to giving a guest lecture, so you must flatter your host. I say that in jest because this quote has been in the working paper since the very first draft I wrote an embarrassing number of years ago. So Levy writes that individual liberty requires that, quote, persons should be free to form any associations or institutions that they wish, to structure and govern them however they wish, and to live according to the rules and norms that the associations generate. Their freedom to create associations and institutions means that the associations and institutions then take on a moral and legal existence of their own. So the individual freedom of association gives us basically a content-independent moral basis for the corporate form. The corporate form is not a matter of sovereign whim. The legal rights of corporations do not exist purely at the sovereign's pleasure. They are, morally speaking, a function of the individual freedom of association. Obviously, that's not an absolute right. I'll get to that. But it is a right that gives associations and institutions moral and legal existence of their own. And of course, freedom of association is not the only right at stake. In addition, we can think of a range of individual rights whose enjoyment presupposes or benefits from the corporate form. Political parties are arguably necessary for fulfilling the right to democratic self-rule. Churches and faith associations are necessary for expressing religious freedom, at least as far as some religions are concerned. Newspapers are necessary for ensuring the freedom of expression and the public right to information. But for the corporate form, these rights would be imperfectly enjoyed, if at all. Where the aggregative approach goes wrong is in the conclusion that it draws from these eminently reasonable premises, which is trying to deduce a corporation's rights from the individualistic basis of their justification. I want to pry those two things apart. A corporation's right to have rights can be justified with reference to its usefulness as a vehicle for individuals to pursue their aims. But its separate legal identity means that it can't avail itself of their personal rights. And in fact, I think we can go further. The fact that certain individual purposes require a corporate vehicle, that is to say, the fact that certain purposes require a separate entity with freestanding legal capacities, I think reinforces the distinction between the rights of people and the corporation through which they transact. So we have to distinguish between the individualistic basis of justification of corporate rights and the personal rights of the individuals. On the other hand, there's no transitivity, in other words. In most cases, the corporation does not acquire or accede to or espouse the rights of its quote-unquote members because it's not a membership structure. It's entitled to make rights claims in its own capacity. And also, the aggregative approach, I think, can't accommodate something quite basic about corporations, which is that we might think that different corporate agents deserve different kinds of legal treatment, including legal protection. Particularly if we locate the moral justification for corporate rights claims and the kinds of individual freedoms that they enable, then the scope of the corporation's rights will have to vary depending on what it is that they do, what purposes, goods, values it allows individuals to pursue. So there seems to be no prima facie reason why a corporation set up for a particular type of purpose should avail itself of rights afforded to a completely different kind of corporation. That's the insight that I'm trying to develop in this project. First of all, there is no shortcut and there is no template that I have to offer. Let's treat corporations like they were individuals doesn't work, because they're different from individuals. They come in a wild variety of forms. And in particular, I have one key distinction in mind. When thinking about what rights corporations have, the main attribute that we need to keep in mind is their purposive nature. And here's what I mean by that. I've already said that individuals establish corporations to further their interests, to realize their ends, to express their values, to live out their life plans. A corporation comes into being for a purpose. I understand purpose to cover all of those things. A purpose may change over time. It may be multifaceted. It may even be incoherent. Sometimes it gets lost. Sometimes it gets frustrated by institutional dysfunction. And sometimes individuals attach themselves to corporations without having any share in its overarching purpose. But the purposiveness of corporations, I argue, makes a corporation a different sort of rights bearer than a human being. It also provides the key to justifying and delimiting their rights. So, individuals also often choose to orient their lives towards a single overriding purpose. Nuns devote their lives to religious worship, Gordon Gekko's to the pursuit of wealth. It's not that corporations have purposes and individuals don't. Rather, it's that corporations owe their existence to the pursuit of a designated purpose or purposes that members acting singly cannot achieve or achieve as effectively. And if we don't take into account that essentially purposive nature of corporations, we might end up gratuitously expanding the range of legal protections to which they're entitled. And here's why that is. Contemporary schedules of fundamental rights, think of constitutional rights, international human rights documents, reflect the important needs, interests, and capacities of human beings. And to that end, they try to accommodate as wide a range of life plans, beliefs, and values that the human condition allows, so long as these are compatible, of course, with an equally wide scope of freedom for others in society. They avoid, as far as possible, assuming any single telos or ergon of human beings. The fact that fundamental rights documents try to leave open the choice of what constitutes a fulfilling human life creates a fundamental mismatch between the legal safeguards that individual autonomy requires on the one hand and that corporate autonomy warrants on the other. Approximating the rights of corporations to those of human beings allows them to help themselves to a full buffet of safeguards designed to maximize the freedom of human beings. In other words, it enables a kind of corporate pleonexia. What we need is an alternative account that tailors the standards of legal treatment due to corporations so as to facilitate the pursuit of their legitimate purposes. Now, what I'm proposing is not a radically new understanding of corporations. I'm trying to give systematic articulations to an idea that we already find in theories of the corporation and equally crucially in legal practice. So first consider that most legal systems accord corporations different legal treatment based on their purposes. So The U.S. Internal Revenue Code assigns different tax obligations to corporations depending on their objectives. Nonprofit corporations have to pursue one of 7 enumerated purposes in order to qualify for tax-exempt status, for example. Many U.S. states, so different kinds of rules are applicable to for-profits and nonprofits, also within themselves. So many U.S. states will empower benefit corporations, so-called B corporations, to pursue a social mission alongside generating returns on capital that distinguishes their obligations from regular C corporations that are primarily responsible to shareholders. And then the third precursor that I want to talk briefly about is the ultra vires doctrine. This is the sort of precursor in 19th century jurisprudence and before that. Many early modern corporations were established by legislative grants of authority or by the state's recognition of their charters, which meant, which was taken to mean that the corporation's activities had to stay within the powers specified in its charter. That was the gist of the ultra vires doctrine, according to which a corporation literally had no power, ultra vires, beyond their power, to act beyond that purposive scope staked out by the charter. So the fact that a corporation was created for a specific purpose was taken to mean that it must conform to that purpose because it is the creature of those who called it into being. Now, the ultra vires doctrine had a very important rationale, which was restraining corporate power. That rationale, I think, remains valid. But the way that the ultra vires doctrine went about achieving that purpose, I don't think is suitable today. Consider that, in the 19th century, a company that was chartered to build railways would not be allowed to build railroad cars. I don't think that that's the way to go. And in any case, the era of the legislative charter is over for the most part. Most capitalist states have free incorporation statutes, whereby incorporation is a mere administrative formality. Corporations have, under the law, have come to be thought of as creatures of unenumerated powers. So the aim of a purposive approach today can't be to limit associative activity in these sorts of hidebound ways, as the ultra vires doctrine did, but to calibrate the burdens that they can impose on others. So freedom of association means that we have to allow individuals to define and revise their collective purposes, to extend or contract them. My focus is on the claim that a corporation is justified in making on others to delineate the claims that it would be justified in making on others, whatever the purposes it decides to pursue. So how do we move from corporate purpose to corporate rights? It's tricky to reconstruct the nexus between a corporation's purpose and the rights claims that it's justified in making. So the mere fact that a corporation has a purpose doesn't automatically make that purpose worthy of protection, much less generate well-founded rights claims. Instead, we have to bring into view the individual rights, interests, and values that vest a particular corporation's purpose with moral significance. Now, that might sound like the aggregative approach. It might sound like I'm peering through the veil and looking at, individual corporators and what they're trying to get. But it's actually quite different. Because remember that the aggregative position posited a kind of transitivity between individual rights and corporate rights. Corporations espouse the rights of their members, and I think it's actually a lot more complex than that. Sometimes a corporation's rights may be justified with reference to the same rights that individual associates have. A church's freedom to interpret religious doctrine may be justified with reference to the religious freedom of congregants. But when a church makes a property rights claim on its own behalf, that property rights claim is not a function of the property rights of its congregants. It's justified by their religious rights. So the veil actually does more work than we sometimes think it does. My point is that corporations have rights because individuals use them to certain ends, and corporations have a prima facie right only to those things that contribute directly or indirectly to the attainment of those purposes. And I say prima facie because, of course, corporate purposes that are repugnant to the public good can't be the basis of rights claims. The state is entitled to ensure that the purposes pursued by a corporation are consonant with the basic framework of a democratic society and with the particular commitments of that body politic. I think of this as mostly a negative test. Furthering the public good cannot be a precondition for association, but hindering some important aspect of the public good can limit the right of individuals to associate for that purpose. Another reason why I say that corporations have a prima facie claim only to those rights that contribute to the attainment of their purposes is because the presumptive right of individuals to pursue their ends through the corporate vehicle often have to be weighed against countervailing rights, values, and interests. And that, in fact, is the nub of most disputes over corporate rights. So let's take the case of Hobby Lobby that I quoted from earlier, a chain store that sells handicraft supplies. It's a privately held corporation. Its shares are owned by members of the Green family. There they are, the Greens, who adhere to a version of Christianity that views certain forms of contraceptive medications as incompatible with the teachings of the Bible. Now, like other large employers in the US, the Hobby Lobby Corporation was required by the Affordable Care Act to provide health care coverage to its employees, and the plans would cover the sorts of contraceptives that the Green family found sinful. So to force the Hobby Lobby Corporation to pay for these drugs, they said, would violate the shareholders' religious freedoms. And the majority of justices on the U.S. Supreme Court agreed. Justice Alito, in writing for the majority, even at some point refers to the Greens by their first names, David and Barbara, familiarizing and humanizing the corporate entity whose shares they hold. Now, if you adhere to a theory of the corporation as a creature of law and nothing more, this whole controversy is a charade. The corporate entity is a legal subject that's not reducible to its members, so their rights wouldn't even come into play. And I agree, as I said before, that the individual rights of the shareholders don't get transferred to the corporation in any straightforward way. But I take seriously the idea that the majority shareholders of the Hobby Lobby Corporation may regard and define their business as a Christian business. They may strive to conduct it in accordance with their faith, much as a kosher butcher may strive to conduct his affairs in accordance with the halakha. But this sincerity does not automatically entitle Hobby Lobby to exemptions from generally applicable laws. Now, a pluralist theory of corporate autonomy, which is what I'm shooting for here, has to allow corporations to pursue these kinds of eclectic and plural ends, such as commercial gain and environmental stewardship for anyone wearing Patagonia gear today, or faith and teaching for anyone who has graduated from a Jesuit institution or faith-linked institution. So when multiple purposes are invoked to impose duties on others, or impinge on their rights and interests, they become controversial. When a particular kind of corporation asks for rights that go beyond those necessary to discharge its basic functions, like being a merchant, in this case, a for-profit business and a large employer, we should shift our attention to those who are asked to shoulder the resulting burden of the corporation's attempt to expand the scope of its rights. And sadly for everybody, I don't think there's a formulaic kind of answer to these sorts of controversies. I don't think it makes sense to dogmatically pretend that, because a corporation is a separate legal entity, no violation of a corporation's rights could ever amount to a violation of the people who associate under its auspices. Hobby Lobby is a hard case, But there are other examples that I gave at the beginning of the lecture that seem to really challenge that sort of argument. And it's quite conceivable that the adverse treatment of a corporation would violate some fundamental interests that the individuals who associate under its auspices have as human beings. So the issue for me is this. It has to be shown that the interests that David and Barbara have outweighs the burdens that would have to be borne by numerous others, for instance, employees of the firm who would be denied certain health care benefits, as well as the public interest pursued by the laws in question, e.g. a uniform system of employer-sponsored health care. Now, anyone familiar with rights adjudication will notice that this sort of conflict is actually quite generic. A rights claim raises questions about the fairness of countervailing duties and vice versa in societies where rights discourse functions as a medium of political debate. Adjudicators have a pretty rich toolkit for addressing these sorts of situations like proportionality and balancing tests. This is good news to me because my theory doesn't have to do all the work. Or consider another example, this one of a religious order that forays into the commercial realm by selling a product for profit. Here, too, there's a claim for exemptions from the rules of the marketplace on religious grounds that has to be counterbalanced against, in this instance, the interests of consumers. That is it's a Hubbard electrometer that the Church of Scientology was marketing in Sweden, both as a way of attracting new adherents and as a way of generating revenue for the church. And the Swedish regulators ordered the device off the market because it could not be shown to do the things that the church promised. And so this case ended up going to the European Court of Human Rights as a religious freedom claim. Did this ban by the Swedish authorities affect the religious mission of the church and consequently the religious freedom of its adherents? Certainly, to some extent. Did those interests trump the interests of consumers and truthful advertising? The Swedish government didn't think so, and the European Court of Human Rights held that it was well within its public policy prerogatives to make that decision. This is what I mean by there's no plug-in test, there's no silver bullet. But the kinds of weighing and balancing considerations that are at stake are ones that, societies that depend on rights discourse are quite familiar with. Now, I want to end by underlining a final set of considerations that are important for answering our question, namely what rights corporations have and why. I've so far made an argument about purpose and said that, unless we tailor the rights to these purposes, we risk inflating corporate power at the expense of others in society. But in some instances, focusing on the rights of the individual associates might end up drawing the scope of corporate rights too narrowly. So the objection is usually that it's too broad, but sometimes it might be too narrow. The fact is that there may be other, even weightier public interest considerations for protecting a corporation's rights than the rights and freedoms of its members. The public may have an interest in protecting the freedom of expression, for example. Often a key consideration in these sorts of controversies is whether or not restricting speech would have an impact on the openness of public debate and on society as a whole. So arguably protecting a newspaper's rights to free speech is not primarily a matter of protecting the journalist or the publisher. It's about protecting the public's right to information, and the quality of democracy, and so on and so forth. Similarly, the reason for respecting the procedural rights of corporations in administrative or judicial proceedings doesn't come down exclusively to the individual right of association that its members have, or the substantive interests that they have in this association. Procedural rights, due process rights, are a bedrock of the rule of law. And the rule of law is a system-wide value. It's undermined if some aspect of public power is exempt from basic procedural requirements just because the agent in question is not one to which we attach particular moral value. So my point is that the constituency of beneficiaries that we should take into account when adjudicating corporate rights claims one way or the other often extends beyond individual associates. What these examples show, I think, is that there is not going to be a one-size-fits-all schedule of corporate rights. No single philosophical concept like personhood, no single jurisprudential test that's going to be able to settle corporate rights claims. There is something quite unsatisfying about this conclusion, and some of you may be regretting the hour that you spent in your seat, because it is underspecified, and it does leave so much room for debate and accommodation. But what the purposive approach, I think, does, and the advantage that it has over the other approaches that I reviewed, is that it urges us to be upfront about how we weigh different interests, values, and ends. Both those that individuals seek through the corporate form and those that society advances through public institutions. We have to leave ample room for contestation over how corporate purposes should be reconciled with the goods, interests, and values that citizens expect their public institutions to promote and protect. So in determining the scope of corporate autonomy in any given case, legislators, regulators, adjudicators need room to exercise that kind of discretion, though hopefully they'll do so in ways that are accountable and both procedurally and substantively legitimate. I'll end there. Thanks. I look forward to your questions.
Before we take the first question, I'd like to add a footnote for the YouTube audience. If you liked this lecture, you might also like two previous lectures in the series, one by David Siepley on very closely related topics, though reaching very different conclusions, and another by the legal historian Naomi Lamoureux, who gave one of our very first RGCS lectures on associational freedom and the development of free incorporation acts in American legal history in the 19th century.